This is a new type of Invent Anything podcast. Today we're going to do a panel discussion with some of the folks at IP Capital Group to discuss a viral trending topic in our industry that stemmed from a Jack Dorsey tweet. So before we dive in, we'll go around the room, do some introductions. I'm Seth Cronin. I'm CTO of IP Capital Group, and I'm joined by Mike, Nathan, and Nancy. Can you guys give a quick intro?
I'm Mike DeAndrea. I've been working at IP Capital Group for the last 15 years in various capacities in invention development and analytics.
Hi, everyone. Nathan DeAndrea. I'm a manager at IP Capital. I've been in the IP consulting space for over 10 years.
And I'm Nancy Cronin. I'm a president and a managing director at IP Capital Group, and been here almost since the start, since 2000.
Awesome. So let's get into this tweet. We don't need to spend much time reading it because it was just 4 words. This was April 11, 2025, delete all IP law. You can see in this thread, Jack is taking the position that creativity is what currently separates us, and the current system is limiting that and putting the disbursements into the hands of gatekeepers who aren't paying out fairly. We can talk about that a little bit more too. Jack obviously has patents. He claims they are all for defense from trolls, see COPA. And this is another point I think we should talk about. Execution and speed matters more. Because one of the questions is, what motivation would there be to create if there was no way to monetize? And then he repeats that point several more times. This actually got a lot of traction. Elon Musk replied to it with one word, agree. And so I thought we'd start here maybe just by kind of steel manning this argument a little bit. I did some research with Perplexity just to see what are the main points surrounding this issue of delete all IP law. One of the things that is clear that you could have, if there was less IP law, you could have promotion of innovation through open access. So open access is definitely one of the things we'll talk about. This idea of monopolistic practices, first of all, having like a patent that inflates the prices of life-saving drugs, protect entrenched corporations over startups, and enable these troll entities. We can talk about that. Simplification of legal systems. It's just very complicated and costly for the US. Ethical considerations about ownership, historic, and then I think AI in future is going to be a big part of this topic. So maybe we can start with this idea of who does the current intellectual property system benefit the most, and maybe who would be benefited the most from some level of reform. You guys have any thoughts on that?
It's interesting. It's almost the same group of companies. It's the largest players in any market that can both benefit by blocking each other from practicing certain inventions with IP, but they're also the ones that benefit the most from the IP not existing, because they could produce whatever widget at a lower cost than the average inventor or small startup.
Yeah, I think it's important too that, I was a little confused with the conversation of whether they're talking more on the copyright side, because, Jack Dorsey and Musk are both building AI companies, and such a big topic right now is the training material for those and use of copyrighted material, and whether that was the kind of genesis of the discussion. But then in the replies, talking about speed and execution, that makes me more seem like he's talking about technology IP, where, that speed and execution doesn't really make sense if you're talking about copyrighted material. So I think we have to separate the two a little bit when we talk about it as well, between kind of technology IP and creative copyrighted based materials. Did you have a sense, Seth, of where that discussion was? If it was more on the kind of IP training side or more to the technical side?
Yeah, so I'm gonna guess that it's more on actually the technical side. I think the IP, the AI training side in terms of copyright is interesting. But from what I understand now, the copyright system is actually not well suited to prevent AI systems from being trained on copyrighted material. Because you're not actually copying the material.
Yeah.
You're doing sort of what a human might do, which is like read it and interpret it and then create derivative output, which may or may not, depending on the specifics, be a violation of copyright. For this conversation, I think we should really focus on the technology aspect because, like, here's the thing. Like, if we back up to say, like, why were patents invented in the first place? It was actually for a couple of things, to really like encourage innovation, so that if you had a monopoly on your innovation, you would be more likely to pursue and commercialize it. Second of all, to actually disclose the innovations that you've created. So by granting that monopoly power, you actually expose to everyone through publication of what your technology is actually doing, which is, sort of the opposite. You could just compare it to a trade secret, right? So if you keep something a trade secret, no one ever finds out about it. No one can ever incorporate that innovation into their next steps of invention. But when you get a patent, you can read the patent, anyone can, and build on top of it. And so there was like this idea that people would be more willing to share their inventions.
We don't use that word enough. Promulgate.
Let's not forget that one of the primary reasons for the patent office to exist was to promote innovation. The idea was that you would get a limited duration of exclusivity, and in return, your patent is published and put out there, and after it expires, or even before it can be used as inspiration for new invention. That was supposed to be part of the virtuous cycle of patenting.
And one thing that I was thinking about in this is that what we're talking about, the kind of genesis of the patent system, that dates back in the US to 1790, and is that still a system that makes sense today with a much more rapid pace of innovation, much more interconnected marketplace of technology and ideas where, things are accessible when they're out there. You don't need it to be published in a patent and be, accessible just to be notified about it. That the 20-year term has changed a little bit over time, but has remained relatively unchanged. Does that still make sense in today's landscape where innovation is so much more rapid?
Yeah, I think you can rely on pharma companies to continue to lobby to keep that duration as long as humanly possible. And it makes sense in a very capital intensive field where there's so much money involved in making a product that is marketable.
Yeah, if you're spending 10 years and hundreds of $1 million in R&D on a drug, maybe 20 years makes sense. But when it's digital based innovations that are developed on such short timelines, and then you're able to get 20 years of protection for it, does that make sense still?
We need different durations for different subject matter areas or different product cycles.
Yeah.
And I guess that, that goes back to what Nathan was saying is, is the IP law that has been built on, but essentially designed in the 18th century, is that still a platform that the 21st century should keep building on? Or maybe with this idea of delete all IP law, is it the thought that it should just go back to being the Wild West, or that maybe we should rebuild it from the bottom up to be more modernized, whether that means speed to, like, the patent system is still really slow too. If I had to critique it as well, I mean, it can take 3 years to get a patent. Like, at the rate and pace of technology innovation, 3 years might as well be 100, right? You could just see, if you couldn't get a patent in your lifetime, no one would ever apply for one. But the technology life cycle is now measured in weeks of when different AI models come online. We saw even in pharma how quickly something like a COVID vaccine can get out. Again, measured in months, not years. So does this historical IP system still support the rate and pace of innovation? And maybe speed and execution is really all that matters. And certainly from the consumer side, you want the best products out as fast as possible. And if IP slows that down, well, maybe it's not the best system.
Yeah.
So
What do you think? What do you think what was behind this tweet from Dorsey? What do you think he's struggling with right now that kind of prompted this on the technology side with IP?
Well, I don't know necessarily what he might be struggling with, but I think there might be another motivation behind this, behind just trying to lobby for actual policy change. And it might just be attacking essentially a lot of the perceived value of patents. Particularly in software industries, the perceived value of a patented application is often significantly more valuable to a business than the actual strategic business value of a patent, which just gives you the right to sue somebody who might be infringing. And to kind of have big people in a particular industry attacking the value of patents, it can severely undermine that kind of that non-tangible value that IP brings.
But there might also be a hint in material that Seth showed earlier. It said that Dorsey claimed that there were far better ways, to I don't know what the exact word was, but to reward content creators, basically the monetary side. But that seems to be ignoring like all the other uses of IP. Like it isn't just using a patent to see how much money you can make. It's all of the things that we talk about all the time about. Does it help with that perceived value in deal making and raising money? And does it give you any sort of gravitas for your brand? He seems to be just interested in that, financial side of, let's go make money.
Wasn't this also what we see, because we work across so many different industries, is people's perception of IP is so limited to their particular industry and how IP impacts that they don't see how it is broadly applicable across all different things, and how the value to businesses is completely different as you go from silo to silo.
Yeah. And I mean, it like gets into areas of just like consumer protection too. If like there's no trademark law, and people can, put out a complete duplicate for Coca-Cola, but it's actually poison, then that's an issue as well. I don't know. That's a kind of out there example, but I'm sure
Or pharmaceuticals, right? You can imagine pulling a bottle of Tylenol off the shelf, and it is not actually that product. It's it's some homeopathic remedy.
Yeah, I think, where most of the issues people have is patents and dabbling into the fair use of copyright. So those seem to be the two areas where there's pushback. I don't think a lot of people, even on something like trade secret, would actually have, fundamental disagreements with the level of trade secret protection. I mean, does Musk or Dorsey really want a high-level executive from their company be able to take all their information, download it from the server, and go to a competitor? I mean, that's trade secret protection. That's IP law. I mean, I think there's basic things that if you push these people, they wouldn't actually agree with. But it's a provocative statement based on smaller, specific pain points.
Maybe that corporate espionage is his plan for future developments.
and that happened. Someone stepped out of Tesla and started Fiskars, and they did sue them. So I delete all IP law sounds really good in a tweet, but I think at least it leads to some interesting conversation like we're having here. Is that likely to happen? No, but there are lots of shades of gray, and I don't know, maybe we should delete some parts of it.
Right. I mean, so like the Musk level of this argument too, and he does this famous interview where he's just said like patents are for the weak, right? They're for people, again, to Steelman his argument. So they're for people who want to, quote, protect their inventions but not be competitive in commercializing them, is sort of his idea. If your invention is so good, then you should be able to execute it without needing to sue other people to stop them from using or selling that invention, right? I want to say I have a cascade of thoughts about this, because like it's easy to imagine, say, like a small creator creating something new and innovative that is a successful product. They say it's an app, they put it on the App Store. And then you have Apple say, wow, this is a really great product. Let's copy it and put it in the operating system so that people don't need to buy this app. Right. So that creator is now totally cut out of the loop. He created innovation. He brought it to the market. People liked it. But then there's a bigger fish who can now just completely copy him, and he has no recourse. The next cascade in that thought I have is, would the patent system actually protect that person, right? Because let's say they have their patent and they go to sue Apple, right? Like what chances are they going to have to actually, like, maybe they'll get a multi-million-dollar settlement out of court because Apple just doesn't want to deal with the legal fees and the brand damage. But I wanted to bring up this recent, in the last couple of years, trend in our industry with I don't know if you guys have heard of this creator, Molly Metz. As an inventor, she had a patent on a new type of jump rope. She's a professional speed jump roper, has clinics and teaches and has gym, things like that. And as CrossFit and the CrossFit games began involving more jump rope activities, there became a huge need for these speed jump ropes that she had invented. And such that the company Rogue, who makes fitness equipment, created a clone of her patented jump rope. And of course, she lawyered up and went and we said we wouldn't talk about PTAB in this, but it behooves us because this is where the patent system is today. A small creator did the right thing, got the patent. Big company cloned her product in violation of the patent. She tried to assert it, and that company was able, through the mechanisms that exist, to get her patent invalidated by combining a French patent and a German patent from like 150 years ago, right? So, like,
because we know that they were both into speed jump roping.
Yeah, exactly, right. So Molly Metz, as the inventor, not only did she get no money from Rogue for stealing her idea, she also got her patent invalidated by trying to assert it, right? So, I guess
isn't that an indictment of her legal counsel more than it is of the patent system?
Well, not necessarily. Her legal counsel has really no opinion in the invalidation, right? It goes.
Well, no, I mean the legal counsel that drafted the patent for her.
Well, yeah. I mean, there's arguments to be made there, I suppose.
I mean, I think we can all
into the
agree
technical
that
details of that case, but I just think that there's so much complexity, and the right question to ask is, like, who does this all serve, right?
Yeah.
Yes.
I think we can all agree that the patent system is far from perfect, and it's abused on both sides of the spectrum. It's abused by small companies or assertion entities who put a tax on large companies and bog them down, even on medium companies. But it's also abused by large companies who have the means to do efficient infringement is the kind of term where they can just ignore IP. And, if you're going to sue me, but, we've got a huge checkbook. We're going to do it. We're going to fight you. We're going to try to invalidate your patent. So there's, kind of abuse and taxing of the system on both sides. So I'm sure we'd agree there's issues with it, but, can you just rip the whole thing up and start from scratch? Probably not. But is there kind of targeted reforms that could, reduce some of that friction and improve the system longer term?
That's a great segue, Nathan. Yeah, go on.
It looks like in the complete absence of an IP system.
Yeah.
Like if you really do delete all IP law, what does that look like? And I believe that you would have a real chill on innovation. There would be, a chill on investment, because who wants to invest millions of dollars in something that you have removed this portion of potential risk protection, as flawed as it may be?
You would only get innovation from the largest players who have the resources to do it, and that's going to necessarily slow everything down.
Right. They are not agile. I mean, these big groups may come out with these products, but they are not rapid. They're getting their rapid development from early stage companies and innovation, the partners they work with, the companies that they acquire. I just think
why,
that it
why
will
acquire
slow
when
it
you
all
can
down.
clone, right? If you can just clone the product with no recourse, why bother acquiring these small companies? Just try
Good
and
point.
clone their product and swamp them out. So maybe we can spend the last few minutes here imagining what like some of those reforms would be if if we weren't going to delete all IP law, if we were going to try and put some lipstick on the pig, what would some of those reforms look like? I mean, I have my wish list, right? Where maybe instead of a 20-year term, it's like a 5-year term in technology, for instance. Maybe instead of having segregated track one, accelerate applications in this normal track, which takes 3 years, maybe every patent that gets submitted goes to track one, and you get your decision within months, not years. Maybe there is not a full monopoly on certain types of technology, and there's more like compulsory style licenses, where if a small or an entity of any size wants to use a patent, they can do it with some restrictions or some complicit royalty that they have to pay on their revenue or profits. Just kind of throwing stuff at the wall and seeing if any of this resonates with you guys, or if you have other thoughts of how you would reform the current IP
Making
system.
the licensing system more efficient and fair would certainly go a long way to this. But I think you touched on what would probably be the biggest improvement. It's not really in the term, it's in the examination period. Like the examination, besides being incredibly time consuming, is horribly flawed, which allows things like the jump rope, where it gets granted and then gets challenged afterwards.
And also, not only is the time long, it's so expensive in terms of attorney fees, filing fees. One thought I have is, what if you could lower dramatically the cost to get a patent, such that companies, and smaller companies especially, are filing way more patents because it's very cheap and it's very easy. And I think maybe what that would do is it would kind of condense the kind of incremental, from one patent to the next patent, that incremental development. You're collapsing that, so the value of any one patent is a smaller jump in between, because it's cheaper to file those smaller incremental patents. So you don't get these patents that are maybe outsized in their impact from a legal perspective, while not really having not being directly correlated to the technology value.
Interesting. So kind of expanding on like a small entity. I mean, there are some price breaks at the patent office for small entities, but I think you'd also have to be careful not to make, if it's really pricing that is across the board, doesn't that just allow large companies to get even more patents?
And given the inefficiency in the examination process is probably the biggest flaw in the whole system.
That's
making the volume higher would be problematic. We also have to consider that the idea that the patent system is going to get more efficient is probably unlikely, as they're likely to have significantly fewer resources going forward, at least in the near term.
Well, then aren't we talking about the elephant in the room, AI?
Yeah.
It can't invent things, but it can certainly invalidate things.
Yeah, I mean, there's pieces of that examination.
I would love to see AI kicking more patent applications out fast. Like, there's no reason you shouldn't have a top-end filter that kicks out, 80% of the applications would easily be rejectable if given stringent examination.
Yeah,
you're voting for an AI guillotine at the front end.
It is kind of amazing that it is the year 2025, and there's no place you could go to the USPTO to like put in a description of your invention and say, can I get a patent on this? Like the USPTO has absolutely no mechanism for a creator to actually figure out any of this stuff.
It's just invest thousands of dollars in filing this and hope for the best.
Right. Or invest tens of thousands of dollars to search.
A lawyer's answer is always going to be maybe.
Well, interesting. Let's finish up here. We'll go around the room and like do some final thoughts of this. I think there are aspects of IP law that whether or not they should be deleted certainly should change. And I think the central problem why this tweet resonated so much is because the speed of government is exponentially falling behind the speed of technology. And IP is like the interface between government and technology, commercial technology. And I think that the widening of that gap is creating structural problems. And so, like, figuring out how the government can close that gap is a hard problem, but it might be like one of the essential problems for intellectual property in the 21st century to solve.
Yeah, to wrap up from my perspective, I think, these provocative statements catch a lot of eyeballs, but I think if you pushed, Musk, Dorsey on these, even they would agree that some IP is needed. And, it's an interesting conversation, and I think it sparks more discussion about what targeted reforms could be done. And I think, those could benefit both sides if done correctly. It could benefit the large companies that kind of these two people are speaking from, but could also benefit, smaller players and individual inventors as well. So it's an interesting area.
Yeah, I know that for years we tend to stand on the inventor side. We're very inventor centric, and I think my opinion remains there. Instead of looking how to kill off things, what are the reforms that are needed to encourage? I don't think you can delete all IP law. I don't think we should delete all IP law, but I'm sure that there's lots of ways to make it better, by rethinking a system that has existed for hundreds of years. And as Seth has pointed out, are we going to catch up? The hockey stick curve, with technology is going up, and the system needs to catch up with it.
As the in-house skeptic, I will certainly agree that the system is due for some reform, but I think it is probably foolish to think that whatever reform we do won't be equally abused as the current system is. Just new and innovative ways to abuse the system. So it will favor a slightly different group of people, but will have ramifications across different industries that are probably going to be unforeseen.
What a great place to end on. I encourage anyone who's listening to let us know what you think in the comments, either on YouTube or LinkedIn, and let us know. Do you think we should delete all IP law? Do you have better suggestions for reforms? Do you think Dorsey and Musk just want to steal your ideas and not have to deal with it when you sue them for it? What's going on here, and what does the future look for IP? We'd love to hear your thoughts on this. Thanks, Nathan, Nancy, Mike. It's been a fun discussion. Let's do it again soon.